Welcome to Just Liberty, where justice and liberty meet. I'm Alan Reinach, Executive Director of the Church State Council, here with my co-host, Bettina Krause, editor of Liberty Magazine. Together, we're trying to recover religious liberty from the political extremes. Well, Bettina, what are we talking about today?
So I'll tell you what caught my eye this week, and that was a new piece of legislation in Louisiana, which the governor has signed into law, which mandates the posting of a very familiar motto in every public school classroom. And it has to be 14 inches, I think, by 11 inches. It has to be very visible. And the words must read, "In God we trust." And
Of course.
yeah, and it stirred some controversy outside Louisiana, but the interesting thing was that it passed unanimously by the legislature down there in Louisiana. So, Alan, any thoughts?
Okay, so bipartisan, Republicans, Democrats, everybody wants to be on God's side. And isn't that the point? When did we adopt that motto? Um, I get the two confused. Under God and the pledge was added during the Cold War, but the motto "In God We Trust" was first put on coins during the American Civil War. And it's interesting. As much as there's always been the tendency to want to invoke, God's blessing on our nation, that God's providence has been leading us, and many of us believe that there has been God's providential leading at many times in our history. But we want to invoke God in support of our own national or personal agenda, and that is fundamentally pagan, right? Because the core essence of all religion is God is sovereign. He's on his throne. He's the creator. And we are, humbly in submission to his will and trying to follow, his will and his authority. But, there's a relationship there. But, clearly, we aspire to doing his will, not having him do our will. That's a, reversal, right?
So that's an interesting take, and one that I have not heard often, that this sort of invoking God as sort of the talisman, I guess, of the American Republic is in a way pagan. I hadn't really considered that before.
No, it is. Now, look, having said that, I mean, "In God We Trust" is a reasonably universal sentiment.
Right.
Although, today, I mean, look, part of the risk, if the surveys of those who no longer affiliate with churches, who the sociologists call nuns, they're not necessarily anti-Christian or anti-spirituality or religion. But one of the things that is commonly noted among them is they reject the political aspirations of the conservative American church, right? And so the more political that we make God, the less attractive the gospel is to those who are alienated from it.
Right. Right. And there is another aspect to this, Alan, which really comes to my mind when I consider the consequences of a piece of legislation like that. And it is, how do religious minorities among us relate to that? And, there was a news story which I was quite amused by. Some design company, a guy down in Louisiana, is having a bit of fun with this whole concept. And he's actually producing some signs, "In God We Trust," in Arabic, in Hebrew, some of them with gay pride rainbows, some of them with even a satanic symbol on one of them. And he's making the point that not everyone, who lives in the American Republic is a Christian. It may be the majority religion for now, but there are significant groups of religious minorities too who can be alienated by this type of politicization of a
But
certain
the
faith.
very phrase begs the question, who is God and who's God, right?
Right. Yes.
Now, there are plenty of religious people who believe that fundamentally those who worship a monotheistic God are all essentially worshiping the same God, despite difference of doctrines and beliefs. But there's plenty of believers who are convinced that those who believe differently are not worshiping the same God, right? There are plenty of Christians who don't believe that Muslims worship the same God that they do, or you know, uh, so it does become problematic. Your question raised in my mind, well, if a Jewish kid sees the motto, if a Muslim kid sees the motto, if a Hindu kid sees the motto, do they think it refers to their God?
Hmm.
I don't know the answer to that question. I
Yeah.
don't. But I wanted to take you back earlier when we look at the origin of the phrase during the Civil War. Um, Listeners, go back and read Abe Lincoln's second inaugural address, because it was one of the masterpieces of public theology, for lack of a better term, because he refused to align God's favor on the North. And
Hmm.
he expressed the view that the war and its long duration was God's judgment on both the North and the South. And it always brings tears to my eyes and chills, even as I'm thinking about it. His eloquence and his refusal to somehow say God is blessing us, God is on our side. He had took a much more humble position, and I think regardless of whether we should or should not post "In God We Trust," how we relate to God is really the underlying question, for us. And do we do we relate to him authentically, that he's in authority over us? Or do we see God as somebody to manipulate? We take him down off the shelf to pray when we have a need, and then we go and pursue our own lives kind of independently.
Right. Alan, this also raises the broader issue that we're looking at more frequently in America, which is, the politicization of Christianity, Christian nationalism. We saw recently an attempt in Texas to mandate the posting of 10 Commandments on the walls of public school
Mhm.
classrooms. We see other states introducing similar bills, and it is indicative of a trend.
But it leads us into our guest, because we're talking about the Establishment Clause
True.
and what's happened to the wall of separation. Certainly in God We Trust, it implicates an issue of whether this is appropriate given our historic commitment to church-state separation. So let's turn to Alan Brownstein. Well, it's my pleasure to introduce our guest today, Emeritus Professor of Con Law at UC Davis Law School, my old friend, Professor Alan Brownstein. And there's few people who have spent more of their professional career researching and writing and speaking about religious freedom and the First Amendment and related topics like free speech than Alan Brownstein. So, Alan, it's a delight to have you on.
I'm always happy to be on any program that you're sponsoring, Alan.
Well, appreciate the endorsement, my friend. So we're going to look at the Establishment Clause, which, traditionally Americans have understood to embrace a principle of church-state separation, but increasingly it seems to be much less so. There's, if we go to the metaphor of the wall of separation between church and state, doesn't seem to be much of a wall left standing these days. But why don't you tell us, kind of what shape the wall is in, and why does it matter?
Okay. The first question is the easiest to answer. The wall has been totally eroded. It no longer exists. The conventional understanding of the Establishment Clause, which meant the government can't promote religion, can't privilege religion, can't subsidize religion, that no longer is constitutional law for the current court. Now the court is allowing government to promote religion through religious displays and sponsored prayer. It's allowing, in fact, it's requiring government to finance religious institutions, even if the religious institution is using those subsidies for religious purposes, for religious activities. So it's hard to identify what's left of the Establishment Clause. The second question is more complicated. Why does that matter? And it matters for several reasons. First of all, it's dangerous for religious liberty. And it's dangerous for religious liberty in at least two respects. First of all, there used to be a general understanding that when government officials have the authority to exercise discretion in deciding who gets benefits and who doesn't, or who is exposed to government sanctions and who isn't, that when a government official has that kind of discretionary authority, he or she can't invite, welcome, or direct people who are subject to that authority to participate in religious activities. So, for example, a trial judge can't ask the attorneys and the litigants before proceedings begin to stand and join the judge in prayer. That would obviously be coercive, intrinsically coercive, because the attorneys and the litigants would worry that if they didn't join the judge in prayer, the judge would be alienated from and less receptive to the arguments that they're going to make during the trial. And another example where we have a Supreme Court case on point was if you go to a city council meeting or a county board meeting, and the only reason people go to those meetings is because they want to speak during public comment. They want to influence their representatives to decide an issue in a particular way. They're subject to the discretionary authority of these legislators, their representatives. And if before the proceedings begin, the city council has invited a member of the clergy to come and to direct the members of the audience to stand and join him or her in prayer, that's going to create an intrinsically coercive situation. Because as a member of the audience who's trying to influence your representatives, you don't want to alienate them. And you're worried that if you remain seated while everyone else stands, or if you leave the room while the prayer is offered, that's going to alienate the very people you're trying to influence. And for many people, standing during a prayer that's offered that is not of your faith, that's inconsistent with your religious beliefs, is unacceptable. It's a violation of your religious freedom. And in Town of Greece versus Galloway, the court upheld that and said that that was not unconstitutional. And we saw in the Bremerton case, the court allowed a coach to offer a prayer at the 50-yard line. And here again, coaches have enormous discretionary authority over the students who are playing on their teams. They decide whether you warm the bench or you get out on the field and play. And there's every reason to think that the team members would be worried that if they don't join the coach in prayer, that the coach will take it out on them by limiting their playing time or doing other things that make their participation on the team less satisfying.
So, Professor, can I just ask you here? I mean, one of the cases you just referenced, Bremerton, Kennedy versus Bremerton. Also, there was another case recently, Carson versus Makin. Both of those are sort of pivotal in shifting the Supreme Court's approach to Establishment Clause issues. The thing is, both of those cases were celebrated widely by many in America as religious freedom wins. So I hear you with your, as you explain why some of these practices which are against the Establishment Clause protections could be coercive. Why are people celebrating them as religious freedom wins? Is there something wrong with our definition or understanding of religious freedom?
Well, I haven't been gifted with the power to look into the hearts and minds of other people. I wish I had. But I can tell you what I suspect, okay? And that is the people whose religious freedom is being burdened in these cases are religious minorities, or the people who choose not to adhere to a particular religious faith. These are wins for religious majorities. There's very little likelihood that the town council is going to invite a majority of Hindus or Muslims or Jews in most jurisdictions to offer these prayers.
The town of Greece case, they were all Christian prayers.
They were all Christian prayers. And the same is true in the coaching context. Religious minorities are minorities. So there's very limited risk for members of the majority that, their children are going to be subject to that kind of coercion, or that they, as citizens, when they appear before a city council, will feel coerced. But that stands the religion clauses on their head, because the purpose of the religion clauses isn't to protect the majority, it's to protect the minority. And the reality is, particularly for a court who claims to think about originalism and history, historically, the greatest threat to religious freedom wasn't secularists or atheists, it was other religions, majority religions who were intolerant of smaller faiths that they viewed as either threatening or as pagan, heathen, undeserving of recognition. So that's what I think is going on, that people have lost sight of the importance of protecting the minority when we're talking about religious freedom. Go ahead, Al.
But I'm glad you raised the issue of history, because what I see the current Supreme Court doing is really turning history upside down. I was taught as an undergraduate about what scholars call law office history, which is history manipulated for a particular result that the judges want to accomplish. So I was encouraged to do an honors analysis of the Sunday law decisions from the early 1960s, which relied on a whole history trying to show that Sunday-led blue laws had become secularized when, in fact, they had such a thorough religious origin. And so they were justified because, after all, they were really just secular and not of any religious significance. But, going back to colonial America, the whole genius of the Constitution was the idea that, church and state function in separate spheres. And that, I think, has completely dissolved. It's not only the court's fault, if you will, it's the rapid expansion of government into every aspect of American life and institutional life. No?
Well, you're certainly correct. There used to be more space for private institutional activity than there is now, particularly with regard to government financial support. But it's true with regard to regulation as well. But I think part of what is particularly problematic here was that the the understanding, the constitutional understanding that you just described about the separation of church and state, that was also a cultural understanding. And as you mentioned, I've given a lot of talks to different audiences, some of which have been relatively conservative, some of which have been relatively liberal. And the liberal audiences will always argue when I advocate in favor of religious liberty, well, why should religion be treated differently than anything else? Why should it be treated differently than any other belief system, anything else that we care about strongly? And I would say, well, if you don't think religion is distinctive for free exercise purposes, would you also agree that it's not distinctive for Establishment Clause purposes? And then the liberals say, oh, wait a minute. No. Clearly, religion is distinctive for Establishment Clause purposes. And I have the same dialogue when I speak to conservative audiences who are saying, when they're criticizing the Establishment Clause, they're saying, why shouldn't religious institutions receive the same funding as their secular counterparts? Why can't government endorse religion in the same way it endorses patriotism? Isn't religion just like these other ideas and belief systems? And I ask them, well, do you think religion should be distinctive for free exercise purposes? And they say, oh, yes, absolutely. And I say, do you see the quid pro quo here? Do you understand that by recognizing the distinctiveness of religion for both free exercise and Establishment Clause purposes and rigorously enforcing both clauses, we create an environment where we maximize freedom and equality for everyone? And for the most part, when I put the argument that way, people start nodding their heads and saying, the guy's got a point here. If we want religion to be treated distinctively for our concerns, well, it has to be treated distinctively for other people's concerns as well. And we've lost that quid pro quo. Now,
I'm going to quote you.
Now, most people think who are unsympathetic to the current court's jurisprudence, they think, and I think with some justification, that religion is being privileged. It's being given greater protection than other rights receive, and non-religious people's beliefs and interests are just entirely ignored. And if you lose the cultural commitment to the religion clauses, and I think you only have that cultural commitment if you take both clauses seriously, then ultimately you're going to lose constitutional protection for both clauses. Because ultimately, originalists can say the Constitution always means the same thing, or it should always mean the same thing, but that has never been true in our history. It's changed dramatically over time, and it responds to our culture, to the values of the people. And if over time people think that religious liberty isn't a privilege, isn't a right that needs protection, but rather it's a privilege that's being used to promote certain people's beliefs over others, they will be much less sympathetic to the cause of religious liberty. That won't happen overnight, but long term, I think this is a treacherous path that the court is on.
It is. I mean, this has been such an interesting discussion because it's ironic, because by expanding the religious free exercise, the scope of that at the expense of the Establishment Clause, those who are doing that are actually cutting the ground out from under their feet. That's basically what you're saying. Yeah.
And let me give you another example. Generally speaking, courts have not probed very aggressively into claims that someone asserts when they say their free exercise rights are being abridged. It's a sincerity test, but it's a very lenient sincerity test. And courts don't look at the centrality of the belief. They don't look at the coherence of the belief. They're very, very accepting of what the claimant asserts as their religious beliefs and exercise. But if religious liberty claims are protected so expansively that people think, we're surrendering an enormous amount of public value to people who are asserting religious liberty claims, and we don't even know whether they in fact believe what they're asserting. Then you undermine religious liberty and you create pressure for the courts to start examining sincerity more carefully, or to say, well, we're only going to protect religious beliefs that are essential to someone's faith. Or we're going to say, we need you to be part of an organized faith. If you have some idiosyncratic beliefs, we're not going to protect them. Because if you allow just about anybody to assert any claim and just put the tag on, it's a religious liberty claim, that's not going to be a functional system for our society. I mean, I think Justice Scalia was wrong in Employment Division versus Smith when he essentially eviscerated free exercise protection. But he was right when he said, we can't just give everyone who asserts a religious liberty claim a get out of jail free card. It says they never have to obey any regulations that they think they assert interfere with their faith.
So, I mean, this has been a fascinating discussion, and I think we've got a lot more to talk about. Maybe we need to do a second part to this, Professor.
Well, you know where to find me.
Okay, great. Thank you so much.
We will certainly find you. Thank you very much. The thing that really stood out in my mind, Bettina, that was frankly new to me, because, you know, I've known Alan for decades and we've worked together over the years, was the idea that, you know, the liberals are pro-establishment clause, but, you know, they don't like the free exercise, and the conservatives like free exercise but don't like establishment. And when he points out kind of what's good for the goose is good for the gander, that you need the balance, you know, people start to see, okay, well, either religion matters or it doesn't matter.
Right.
And if it matters, it has to matter for both clauses in order to protect religious freedom. So I thought that was very helpful, because I've been very concerned that from a secular standpoint, there's no real reason to want to protect religious freedom.
Right.
You know, because if you think about it, if you're not a believer, religion is at best a relatively harmless myth. So why should that be protected? And at its worst, as we know historically, religion has fueled violence and intolerance and, you know, all kinds of ugliness. And so surely that doesn't deserve protection. You know, so there's a good secularist case to be made against religious freedom. And I think we believers need to really step up why it's important to protect religious freedom for everybody.
Right. And building that culture of religious freedom that's going to survive and thrive into the future means being concerned about the reputation of religious freedom today. And I think, as Professor Brownstein said, you know, by focusing as people of faith, if we focus too heavily on religious free exercise and we're not concerned about also maintaining those strong establishment clause protections, you know, we're getting ourselves in trouble in the long run. You know, it's interesting, Alan, I, as you know, worked in international religious freedom before this current job. And let me tell you, I visited many countries and I met with representatives of governments whose constitutions had these fabulous, you know, articulations of religious free exercise in them. You know, we protect the right of every individual to believe according to but
on paper, just on like paper. Company policies are great on paper. It's the practice that falls short.
Practice, and that's the thing. And then you would go and visit the minority religious groups in those countries, and you'd talk to them, and they'd say, "We are hamstrung by blasphemy laws, you know, which protect the majority religion in this country. We're hamstrung by apostasy laws, which say it's illegal to change one's religion." You know, and so the practice of religion was not protected because they had the free exercise protections. They didn't have the establishment clause protections, which allowed a government to put a thumb on the scale in favor of protecting the majority religion. And that's why our Constitution, the US Constitution, is so wonderful, because of that complementary action between the two clauses.
Well, on that note, we will have much more to discuss about the Establishment Clause in times to come. This has been Just Liberty, where justice and liberty meet. I'm Alan Reinach here with Bettina Krause. Until next time, remember,
Eternal vigilance is the price of liberty.